Next on the docket, a busy spring session for the Supreme Court. Now, we're going to focus on two cases in particular that could have a major impact from coast to coast. First one, it deals with the census. It's important because it determines the populations in different areas, and that decides the number of both congressional seats and electoral votes each state would be granted. Now, the Trump administration, they want people to say whether or not they're American citizens on the census. Critics say that would lead to a major undercount, especially of those people in blue states. Now, the High Court also taking a case on LGBT rights. That's considered a major test case. It involves people who claim that they were fired because of their sexual orientation. The issue before the court, whether or not the Civil Rights Act of 1964 protects gays, lesbians, and transgender people. It's hard to believe we're still debating this in 2019, but here we are. And joining us now, Washington Post Supreme Court reporter Robert Barnes. Robert, thank you for the time. I appreciate it.
Thanks for having me.
Well, it seems if you read the tea leaves that on the census case, it looks like the court's leaning to put that question on the census, much obviously to the pleasure of the president.
Yes, the Trump administration wants to add this question, and groups, as you say, in blue states, some civil rights groups, they say that it shouldn't be asked. It's a complicated thing. The question has been asked for years, decades, hundreds of years in some form. But since 1950, it has not been on the short form that's sent to every household. And there is a worry that this question about citizenship, especially in an age of enforcement of immigration laws, that it would cause some people not to answer the census form.
Let's move to the case as it relates to sexual discrimination. Were you surprised that the court put that on the docket for this session? And are you also surprised it's even up for consideration? A lot of people thought it was settled, apparently not.
Yeah, a number of people do think. I think polls show that most Americans think that someone can't be fired for being gay or for being transgender, but actually only 22 states and the District of Columbia have laws that protect against that. The question here is whether this federal law passed in 1964, it says that it protects people, quote, on the basis of sex. And most courts have found that that doesn't include sexual orientation or gender identity. But a couple of courts, major federal appeals courts, have found that that language is broad enough to protect those workers. And so the Supreme Court basically had to take the case because you have some courts saying one thing, other courts saying something else.
Moving away from the cases at hand to at least the president and the High Court, when pressed, he said he's not going to cooperate with any of the subpoenas. And then he said, quote, I did nothing wrong regarding, obviously, the Mueller probe. And he said, if the partisan Dems ever tried to impeach, I'd first head to the U.S. Supreme Court. Now, Robert, we've only gone through this twice in our nation, but hasn't the court specifically said this is a political decision for Congress regarding impeachment, that the role is not that of the Supreme Court to be the arbiter?
Yes, that's right. The president said what he was going to do, and perhaps he would try it. But the Constitution says that impeachment proceedings start in the House, and if impeachment is found in the House, then the trial is in the Senate. The Chief Justice actually does have a role in that. He presides over the trial in the Senate, but it's not a question for the courts, it's a question for Congress.
In terms of the court more broadly, I'm not trying to be Pollyannish, Robert. I understand, obviously, by definition, a Supreme Court appointee at one point was a nominee selected by a president, so there's always politics involved, or at least perceived politics, as to the leanings of the justice. That said, do we have any sense as to whether or not that the court is even more politicized or more weaponized, if you will, than the past?
Well, I think what's really different about this Supreme Court, and it's something that's different about it that hasn't been this way in decades, and that is that all of the conservative justices, the 5 conservatives, were all nominated by Republican presidents, and the 4 liberals were all nominated by Democratic presidents. And you could say, well, that makes sense, that's the way it happens, but that really hasn't been the case. There have been justices appointed by Republicans who turned out to be liberal members of the court. There have been Democratic justices who turned out to be conservatives. And so what you really have on this court is that these ideological 5-4 splits also mirror the political parties that nominated them. And I think that that's what the court is worried about. I think that that's where the sort of public relations and the public image of the court is in danger, in that if these 5-4 decisions begin to be portrayed as the 5 Republican nominees against the 4 Democratic nominees.
And finally on that point, Robert, maybe it's just a perception, but it seems that Justice Roberts is very aware of what you just mentioned, and he takes pains not just in his words, but one would even argue, certainly with the Affordable Care Act and others, to try not to always be a predictable 5th vote one way or the other. Is that just my perception, or do you think that's conscious on the part of the Chief Justice?
Yeah, well, he's pretty predictable. I mean, he sides with the conservative members of the court far more than he does the liberals. As you say, the sort of marquee case in which he didn't do that was the Obamacare, the Affordable Care Act, but that's really the only one in which he's made a huge break with the conservatives. But he certainly is worried about the court's image. You know, he sort of rebutted the president last fall when the president had been talking about Obama judges. He said there are no Obama judges, there are no Bush judges, there are no Trump judges, we're all judges just trying to do a good job. So as the Chief Justice, you know, there have only been 17 of them in history. I think that he considers part of his job to try to explain the courts and try to guard the judiciary's independence.
Robert Barnes, thank you so much. I appreciate the time.
Thank you.
Up next, the right to know versus the need to know. Prosecutors want to release the video of Robert Kraft at that day spa as part of their solicitation case against the owner of the Patriots. Yes, that video. Even if the judge rules they have a right to do that, do we really need to see a 77-year-old guy on the massage table? I'll talk about that and more with our legal panel.